Mr. Lambert.
Sure. Just briefly also, I think a big part of this is the timing of it. It may seem activist, as he says here in 2009. It may seem like it's an implicit repeal if they went our way in 2009, but back in 1992, when they looked at the same issue, they saw it a different way because it was so close to the 1986 Constitutional Convention. I've maintained, just as a matter of common sense, that if this case were brought in 1989, we wouldn't all be wringing our hands and wondering what the legislative intent was. I think most Rhode Islanders knew what the intent of 6 in 1987. The court knew what it was in 1992, and that's why they issued an advisory opinion that really coincided with the arguments that the Ethics Commission made. 22 years later, memories fade, and that's why it's so important and I guess necessary to, if you're looking to change it back to the way it was for the last 22 years, we do have to be more express. That's the only way going forward. The court has ruled, and so that's the only option at this point, to just go back in and clarify exactly what it is that we're trying to do, that you're trying to do. Oh.
I know that Mr. Flink has a question, and then we'll probably have time for one more.
Senator Roney, I understand that you are here as an individual and not in any kind of a representative capacity, but you are rather close to members of the Senate. And I have a question related to your comments about the appointment clause. I would like to know whether you know of any senator who has publicly stated that the Ethics Commission might be subject to separation of powers. I think you suggested that may be one of the problems with the Ethics Commission, that their members had to be appointed in accordance with the separation of powers. Did I understand that correctly?
Yes.
I want to know whether I'm requesting you to tell us whether you have ever heard any member of the Senate take that position.
Those of you who know Alan Flink know that a request is not necessarily a request. First of all, don't use the term separation of powers to refer to, you're talking about the appointments clause. There's a tendency to lump all these things together and call them separation of powers. But this was the appointments clause. No, the answer to your question is no. I have not had any discussions with anyone in the General Assembly that say that those appointments are possibly defective.
You're under oath,
But I believe they are, and it won't come from the General Assembly. I think it'll come from Max Listow or John Tarantino or lawyers like that with clients who are going to start looking for ways to challenge the activities of the decisions of the Ethics Commission.
Thank you.
Thank you.
One more question?
My name is Frank DiGregorio, and I sit on the planning board in the town of Exeter. And my question is, does the court ruling apply just to legislators as far as the speech and debate, or does it apply to all officials? And if it doesn't apply to all officials, is it prejudicial?
Mr. Graham?
Yeah, this ruling only involved the application of the speech and debate clause, which only applies to members of the General Assembly. And so the speech and debate clause should have no application to municipal officials. There are issues of common law doctrines of legislative immunity that can and have been applied to municipal legislative bodies like school committees or councils, but the speech and debate clause shouldn't have anything to do with that. And so the position of the Ethics Commission is that we continue to have full jurisdiction over those types of bodies.
Bender?
Because as you said, there's a common law legislative immunity, which actually was the precursor to the constitutional immunity. But it is something that can be abrogated by statute. And the ethics code statutes that exist right now have abrogated it, in my view, with respect to municipal officials, with respect to the ethics code itself. You know, if some disgruntled person wanted to sue you, you know, on a personal basis, then you could assert that legislative immunity, that common law legislative immunity, but not if the Ethics Commission wanted to prosecute you.
Mr. Friel, I want to slide one more question in here, which I know has no legal significance, but you did just say that there's an obvious conflict between the Ethics Commission and the speech and debate clause. What is your answer to why no one, as far as I know, said one word about this for 22 years?
You know what? That is a good question. I don't have an answer to that question. At the same time, anybody who knows anything about how common law and case law evolves knows that questions come up all the time that one might say, "Oh my God, how did this not come up before?" I mean, you know, the U.S. Supreme Court just in the last few years issued a huge decision about gun rights and the Second Amendment that addressed some issues that hadn't been answered in a long time. The Supreme Court just had an argument about the Hillary movie and about the impact on campaign finance and raised big questions about the role of corporations. Why do these things not come up? Because cases bring them to a head. And this was a case.
But I'm asking why no one even mentioned it. Why wasn't it in an op-ed?
I don't know.
Why wasn't it in a debate at the Constitutional Convention?
I don't know. I don't know the answer to that, except to say that these cases come forward when a hard case brings them to a head. And this was one. It was a prominent case, a very widely and well-known politician in the state, got a lot of press. It was pursued, and it came to a head, and it brought the issue to a head. Why didn't anyone mention it sooner? I don't know. Maybe John Roney mentioned it earlier. I don't know. Did you, John?
I wish I had. But the right of an accused to have a lawyer did not exist until Gideon Wainwright raised it.
Nobody said it was obvious that you had that. He said it was obvious that these were in conflict. And if it was so obvious, it seems odd that no one mentioned it.
And it may be, and that also may be, in some ways, a testament to the fact that there wasn't any question for quite some time about the ability of the Ethics Commission to regulate other aspects of people's behavior, and that this was just a sort of a perfect storm, kind of a test case, where it went right to the core, given the way that the accusation was structured, and I want to emphasize that. Given the way the accusation was structured, it went to the core of that legislative activity that's protected by speech and debate. And I don't know if it was the first case that potentially raised that issue in those 22 years, but it was certainly the first one that went this far and brought the issue to a head.
Okay. Tom, go ahead.
If you look at the history of it, the reason that it was never brought up was because it was the General Assembly itself that created the Conflict of Interest Act, the Conflict of Interest Statute, and it was give the General Assembly credit. They addressed the ethical controversies that were going on at the time by creating an all-encompassing administrative agency that could address it, and they included themselves in it. And they were included in it for 10 years before the 1986 Ethics Amendment, and the Ethics Committee wanted to continue that. And then immediately afterwards, the General Assembly enacted statutes that also gave evidence that they were included within, their core legislative activities were included within that. That's why nobody raised it before, because everybody assumed that it applied.
Okay. I want to thank everyone for participating and sort of echo Senator Roney's comments. At a moment in our nation's history where people really are questioning civility in government and in public forums, I completely appreciate the way in which we have civilly disagreed quite a bit tonight about these questions. So I want to thank everyone on the panel and thank all of you for coming.